Hi, I'm Adam Seifer, a partner with the law firm of SeiferFlatow in Charlotte, North Carolina, and head of the firm's criminal defense and driving while impaired practice. I'm here today to discuss what happens if you refuse to provide a breath sample at the police station after being arrested on suspicion of driving while impaired, or DWI. When the officer requests that you provide a sample, you have the right to refuse to provide a breath sample. However, if you refuse, your license will be suspended for a period of 1 year solely on account of the refusal and regardless of the outcome of your actual case. So you may ask, I thought I have a constitutional right against self-incrimination. How can I be punished for refusing to provide a potentially incriminating breath sample? The reason that DMV can suspend your license for refusing to blow is because our courts have said that driving is a privilege, not a right. By driving on public streets, you have in essence given your consent to be chemically tested upon suspicion of DWI. This is why DWI is called an implied consent offense. When you drive, it is implied that you will provide a breath sample. You have the right to refuse, but DMV is allowed to penalize you by suspending your driving privileges. If you refuse, the officer may still transport you to the hospital and obtain a search warrant to draw your blood to get a blood alcohol concentration reading. Some officers do this, some do not. It's within their discretion completely whether they do this. If the officer does not draw blood, then the state will be limited in its ability to directly prove that you were impaired while driving. If the officer marks you as a refusal, you'll be notified by DMV that your driving privileges are going to be suspended for a year for refusing a chemical test. However, you can request a hearing to challenge the grounds of the willful refusal, and as long as you request the hearing before the suspension begins, the suspension will not commence until you have had your hearing with DMV. Therefore, if you are marked as a refusal, I recommend meeting with an experienced DWI attorney immediately because of the time sensitivity involved in challenging the refusal. If you have been charged with the crime of driving while impaired, please call me and the law firm of SeiferFlatow today at 704-512-0606 or visit us on the web at www.seiferflatow.com for a free consultation.